You're listening to the Immigration Lawyers Toolbox Podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode number 389. It's going to be an interview with our great colleague, Gregg of the Immigration Review Podcast. If you're an AILA, you probably saw him in person. I'm so used to seeing him on video. Every time I see him, like, you're much taller than I expected. He's always crouching, slouching a little bit, but he came with his baby. It was a wonderful session. So we're doing our talk and discussion about cases that were up in June 2025 at immigration law. And I'm lamenting my sadness of all everything that's going on. So that's not the most upbeat one on my part. He's positive. He keeps it positive, though. But that's the episode that we had there. I do want to thank the sponsor of the episode. You all know them already, but they're a great friend of the show, Serenade by E-Immigration. I recently caught up with the folks at E-Immigration who shared a big announcement at the conference, hot off the presses. Have you heard E-Immigration is now integrated with VisaLaw.ai? Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI. Again, that's get.eimmigration.com/VisaLaw.ai. So thank them sponsoring the upcoming magazine. If you haven't checked out our magazine already, we changed the website, hosting magazine. But if you go to Toolbox, our website, immigrationlawyerstoolbox.com, it should be there. I got to double check actually to see if my staff member put it there. But we have issue 10 coming. We're collecting articles. A lot of people are late. So we're going to collect these articles and publish it. A lot of good information. It's mostly business immigration kind of stuff. A lot of people want EB1A material, so EB1 material. So it's gonna be that in. But I mean, speaking of EB1, we have our course out now too. That's really special. Our EB1A Extraordinary Ability course, going through like just redacted copies, how to do it, front to end. It gets you really up and running. If you're already a member of our community page on circle.so, you could click on the link for EB1A to pay for the premium course. It's not free; it's a paid course. And if you're not part of the free community page for lawyers, that we share white label content, special training materials that anywhere else, white label version of my law firm content. For example, list of bona fide documents we give to clients, like a checklist is free there, and a lot of other material like AO decisions. You can check it out. Just email me with your bar information, name and bar info, and I'll add you to that Circle.so community page. And so that you could get involved in the immigration space there. And if you want to write an article or you have expertise, something, let me know. We'll get you on a CLE, on a podcast, or something else if it works out. Having said all that, thanks for listening. All the information provided here is not intended as individual legal guidance. Please consult with an attorney about your case, but you all know that already. Let's get it started. Good to see you again. This is pretty cool. I got to see you in person, or once a year meeting in other states.
That's
in Colorado.
That's right. And now that I've seen so many of your videos coming that you did in the vendor area, I'm kind of upset that we didn't do one. I mean, I was upset at the time.
Yeah, it just makes more sense. Now I'm going to be organized. So for those who don't know, I had a booth at the conference this year. What I did is I walked around just talking with different vendors at the conference, and my phone just talked for 3 minutes. And afterwards, I'm like, oh, there's like all these people like you and like 5 or 6 people like I should have just sat down and talked with. We planned to talk about it, but it's kind of so crazy. When you have a booth, you really need to have 2 people there, because when you're doing it alone, there's just so much talking going on, especially when I want to go meet the vendors, that like it's just a learning lesson. Yes, you're San Diego, so it's your hometown, but I'm going to come prepared, probably bring my wife with me at the booth and just have better systems so I can manage it.
It's wild. I mean, AILA National is so busy. Like the vendors and all of the panels that you want to go to, that you've paid to be there to go. And then the non-panels, the small group meetings and immigrants list lunch and so many things that are so important to the immigration world. It's it's really long. I think they should like spread it out and like maybe not make it so jam packed. But no, that's
it's like bittersweet. Like more days, but at the same time when you come back, then you have all this work you got to catch up on. But it's just there's so much going on at these conferences. And I mean, the AILA National is like the best conference ever, probably. I mean, I don't know many other conferences, but the immigration space, particularly the AILA National, is just like really fun.
I'm a pretty big water skier. I think I'd enjoy a water skiing conference a little more. But other than that, maybe
And when I was there, a
it's
lot
a
of
good
listeners were there, and they always said, "Oh, I learned about you the Kevin Gregg podcast and all that kind of stuff." So it was really good.
Well, that's cool, but I get a lot of people who come to me. I saw you on the video, is what they say to me. I'm like, that's not me. I saw you on your podcast video. I'm like, that's not me. That's John's show. I don't do the videos. So I guess it's both
Yeah,
ways
but that
there.
mutual help that's happening. There's so much to talk about right now. I guess the best is just keep it positive because you got some good cases. It's July 1st, when we're recording this. So a lot of big news happening. That's pretty depressing. So
Yeah. I don't know how much time. There's a lot. I mean, I got 5 cases here, but even actually not even on the list, and it hasn't hit the media yet. We, with the law firm Brian Cave, Just Futures Law, and others, just won the TPS early termination for Haiti case. Just today. It hasn't hit the news yet, but the order has been published. The judge said it was unlawful under the APA to terminate TPS early for Haiti, which would bring back the February 2026 termination date. Now, that literally happened a couple hours ago. We moved for partial summary judgment, so I'm not even sure if the government can appeal that, but the case, who knows, the case might be over in 2 weeks. It's complicated. We only sued on the partial vacature. The full vacature, the early vacature, the full one, the complete termination, that only happened, I think, effective today, actually. So whether TPS can eventually be terminated lawfully is a lawsuit for another day, or maybe an amendment to our current one. But what was achieved today is that the DHS secretary can't do what they've literally never done in the history of this country and terminate TPS early when it was supposed to terminate in February. So not August, yes, February for now. And we'll see if the government appeals that. But lots of important decisions were in that. And, this comes 2 days after the Supreme Court's Casa decision, which I'll talk about soon, the birthright citizenship case, which, of course, was not about birthright citizenship at all. But there was a very important footnote in the majority opinion and in Kavanaugh's concurrence about how, okay, no more nationwide injunctions in immigration, it seems, but APA, Administrative Procedure Act, set aside and vacatures, fair game, to paraphrase. So this judge clearly had a decision drafted, waited for the Supreme Court's decision, found the APA stuff. Our case, of course, travels under the Administrative Procedures Act, and issued this decision. And, of course, he's relying on Kavanaugh's concurrence and the other language in Casa. So this might be the first decision post-Casa about nationwide relief. Now, this is nationwide APA set-aside, but for the practical Haitian on the ground, it doesn't matter how you got there. So it's important that happened. That happened just a couple hours ago in the Eastern District of New York.
But there's so much to talk about, so the shorter answers are better because we have so many cases. But it's hard to talk about the stuff in a short fashion. But for the Haitian TPS, does that same kind of stuff apply to the other TPSs they're cutting short? Or am I correct? They're cutting short a bunch of other ones too, right? Or are they just letting them end on their own?
I'm not an expert on the other TPSs. I feel like they only cut short Venezuela, but I could be wrong about that. We only sued about Haiti, just like last time. ACLU's lawsuit's a bit broader, but they went up to the Supreme Court. They got an injunction. Did they get an injunction? I can't even remember what happened. It's been so much, but yeah, ACLU's doing the Venezuelans. There's other lawsuits out there too, but this is important. It's important stuff, but ours is always only about the Haitians. This is piggybacking on what we did during Trump 1 in the Sage case. This is the Haitian Evangelical Clergy Association, HECA, v. Trump. And during Trump 1, it was Sage v. Trump.
Were you guys involved in the duration of status F1 visa lawsuits last time?
We were not involved in the F1 lawsuits, no. But I mean, I know about them. A lot of good attorneys were.
They just announced they're going to update the codified regulations and take away to yes. I was going to see that's going to be a media lawsuit that happens. I'm assuming again.
They're going to take away what duration of status
on it instead. Yeah,
of course. I mean, look, it's always there is a price to pay from litigation, and that is a administration who doesn't like to be sued, if they have the power, will take away your bases for suing if they can change the law.
Definitely. Okay, so let's jump in with the good cases that you always bring.
We haven't jumped in.
Well, that's
we're knee deep, but I'll talk about Casa. The Supreme Court issued its end of term decisions last week, June 27th. Trump et al. V. Casa, the birthright citizenship case, which isn't about birthright citizenship at all. I can't talk about. I'm not going to talk about this case long. I mean, all the good Supreme Court podcasts talk about this and all that, but Supreme Court very easily could have decided birthright citizenship. The dissent makes the point that the U.S. government wasn't even defending the merits of the executive order, and instead they have pushed this for at least a year, putting all these people in limbo to make a point about injunctive relief, nationwide injunctions. That they picked this case to do it is extraordinary to me. And now we're in this situation where people are worried about their citizenship in multiple states, even though the U.S. government has a borderline frivolous argument in defense of the executive order, which is what this decision does. It's what the dissent points out. They have taken away, it seems, nationwide injunctions, certainly in the immigration context, but it seems a lot broader than that. The ability of a district court to enjoin unlawful executive action nationwide. You can give the relief to the plaintiffs in front of you, maybe class actions, although class action relief in immigration is very difficult in some contexts because of a decision 2 terms ago. But even so, it costs $500, $400 to file suit in federal court, and tens of thousands of dollars in attorney's fees, not to mention the time. It is not practical to force litigants to go into court every time they need their rights vindicated for blatantly unconstitutional actions. I mean, taken to a logical conclusion, and I am cynical enough to say a future Supreme Court might say otherwise, doesn't seem to be much to stop a future administration from saying no one's allowed to have any guns in America. No more guns, can't have them. Blatantly unconstitutional. But you couldn't get a nationwide injunction for every person in America, it would seem, based on this decision, even though it's blatantly unconstitutional. And that's crazy to me. Every gun owner would need to file their own lawsuit, for example. So that is what the Supreme Court majority just did. The dissents were saying this could be the end of our democracy. Who am I to say otherwise when Justices Sotomayor and Jackson seem to think that, and they're much smarter than me. So that is what happened. That is Casa. But as I mentioned, seems to be a carve-out for Administrative Procedure Act cases. Those are vacature set-asides, not injunctions. And for class actions in the non-immigration context, at least, mostly. So there is ways, but in nationwide relief, it's a big deal.
If like people exactly read it, but it's like, could you go to circuit? Could a circuit court issue that, or could you do a circuit-wide injunction?
This is about the power of district courts to issue, and you can't just go into circuit court. I mean, the district court gets appealed to the circuit court, which gets appealed to the Supreme Court. Now, there actually might be a special rule for the Supreme Court to be able to issue injunctions itself, which I think comes from the Constitution, but
it's not practical.
Going directly to the Supreme Court is an extraordinary thing that most litigants can't do. Now, this is a big deal. It's a very big deal.
Yeah.
And so that's what happened.
That's a shocking situation altogether. What do we have? Yeah.
Well, I mean, as the Supreme Court talks, so just keep your eyes out for Riley v. Bondi, June 26, 2025. Essentially, the Supreme Court said that the 30-day petition for review deadline, post-final order of removal, is a claims processing rule, not jurisdictional. That means it can be extended and equitably told if the facts are there, it would seem. And it means that OIL can waive it. They need not assert it. So that is a decently big deal. But on the other hand, for the Pharaoh context, where ICE expeditiously orders someone removed, the 30 days of petition for review begins with the Pharaoh, and not when withholding of removal and Convention Against Torture Protection is denied in withholding only proceedings that follow. So that's a giant trap.
What's Pharaoh?
Seems inequitable, but it's a final administrative. It's what ICE does when they expeditiously remove someone. ICE says the final administrative review order. ICE says, hello, green card holder. We think your conviction's an aggravated felony. You have 10 days to prove to us, ICE, that it's not. How often is ICE going to disagree with itself? So you get a Pharaoh 10 days later, which is the final order of removal, instead of putting you in removal proceedings, even though, for example, you might be an LPR. I believe you can get a Pharaoh as an LPR. It's the expansion of expedited removal that seems permitted by the statute, by RIRA, that just hasn't ever been used. But Trump and Stephen Miller are trying to maximize immigration law to the maximum extent possible, even sometimes beyond what seems permissible. They issue a Pharaoh, and then you're gone, unless you can pass your reasonable fear interview and are placed in withholding-only proceedings before an immigration judge. So you can't even readjust status, for example, because you're in withholding-only proceedings.
Wow.
Withholding-only proceedings, then, assuming you have this fear, are going to take a long time. Like to bring your claim, to get a decision. They're complicated. Supreme Court just said is you need to petition for review to the circuit after the FARO is issued, even though you're litigating withholding only proceedings at the same time, it would seem. Because if you don't, you're not going to be able to petition for review the denial of withholding of removal and CAT at the end of it. It's very complicated.
Well, to add insult to injury, I just got done ChatGPTing the new big beautiful bill, quote unquote. They're going to have long-term detention for people in that situation. It's going to hold on to them for years until the court pays.
Oh, they're giving them billions of dollars.
Prison complex just is a giveaway. It's insane. Like massive farms of people, just slave labor again.
It's very scary.
It's insane, as to put it lightly.
Wild.
But that's coming. Yeah,
I thought we were trying to be positive.
I was just putting our review. I was just ChatGPTing the sections of it. I'm just like, whoa, this is insane. Hey, I wanted to jump in the midst of all this just to remind you about our EB1A Extraordinary Ability course. If you want to expand your practice and get into a business space, employment kind of greeting cards, self-petitions. So you don't need an employer for these. Self-petitions, EB1A. We have the course for you. And if you're already doing it, we want to expand or get my opinion or get some redacted samples that we have. We have one for the scientist. We have one for a swimmer, athlete. We have one for a YouTube star, social media star. And I'm going to try to redact and add more into the system. But the course is on sale on the Circle That So community page. If you're not a member already, you have to be a lawyer, private bar lawyer. If not a member, email me with your name, bar info. Let me know you're interested in the EB1A course. So you let me know if you just want to join the community. But if you want the EB1A course, let me know. So I'll send you a link to guide you where you need to go to get that. But definitely, it's hot off the presses. Get started by growing your practice now. Now's the time. There's a lot of changes happening. EB1A is not going to be hit as hard probably. So it's definitely worth looking into. Having said all that, let's get back to the show.
Well, let me go to the very positive ones, both from the D.C. Circuit then in actually May 30th. Well, two of them. Pietersen et al., the Department of State et al., Doctrine of Consular Non-Reviewability. Yeah. Always interested in a case about this, especially where here they got around it. It's incredible. You of course are aware of a 201G letter which says, we're not letting you in. There's reason to believe you're inadmissible, right? And the FAM permits that. And so this person, she was trying to, I think, get a fiance visa, but she had been here a couple times and helped her friend on a horse farm. Maybe got paid a little bit. It's very milquetoast stuff. These decisions sometimes. And they were saying she had committed fraud or willful misrepresentation, so she can't live in America with her fiance, soon to be husband. And she kept getting denied. And so they didn't sue on the denial because that would probably be barred by the Doctrine of Consular Non-Reviewability. What they sued on is they said, we're going to be harmed in the future when we apply again. And the harm, they said, the Department of State is applying the law wrong. The law requires an inadmissibility finding, not a reason to believe they're inadmissible. Don't get me wrong, drug trafficking, money laundering, inadmissibility, those permit an inadmissibility finding based on simply a reason to believe. But the other things require a substantive decision on inadmissibility. Did they commit fraud or willful misrepresentation or not? Not simply that there was reason to believe. The whole 201G letter thing appears to permit barring entry based on suspicion. And the FAM seems to permit that. So they sued the FAM and they won. This is in the D.C. Circuit, which makes it even more important. It was remanded, I think, probably for further analysis because I believe the district court said, well, I can't look at any of this Doctrine of Consular Non-Reviewability. The D.C. Circuit said, no, they're suing on a future application of the law, not on a current denial of a visa. Fascinating stuff. Amazing lawyer.
You know who it was?
Of course, I always say it. It is Carl W. Hampy and Daniel P. Pierce and Daniel D. Schaefer.
Congrats on creative arguments that work, especially D.C. Circuit. That's a tough one to take it to, isn't it?
Amazing. Another D.C. Circuit then that I'll get to that I wasn't even going to talk about. Same day, May 30th. It's been a wild month for the podcast. Castanera v. Noam, published by the D.C. Circuit on May 30th, 2025. This is about the Adam Walsh Act. This is an argument that our firm brought to the 11th Circuit, and it looked like we almost got a win. We certainly got Judge Jordan in dissent, but it ended up being a loss, and that is this. Adam Walsh Act, the no-risk determination. If you've been convicted of an offense that's, and I don't do Adam Walsh often, but, the sexual abuse of a minor, those kind of offenses, and then you try to petition someone else, you have to convince USCIS that you have no danger to the person you're trying to petition. And it makes sense, right? If you have a sexual abuse of a minor type crime, child pornography, anything like that, you don't want those people necessarily to be able to petition for children or for people with children, foreigners with children, for example. But it often comes about, including in our case, you've got someone with a conviction, U.S. citizen, many years ago, and now they want to marry a U.S. citizen of their age with no children. I've never understood the policy of not permitting that. It would seem that would, if we're assuming these people have some sort of issue and that they're more prone to reoffend, I would think that an adult partner.
Well, what's crazier is if you do a parent immediate petition, it still applies to them too. So it's any petition. Yeah, it's like your parents.
That's your parents. It's wild. It's completely insane. It seems like an unconstitutional punishment, but I guess that hasn't been brought up. But the argument is this: what standard of review is applied to the no risk determination that you don't pose a risk to the person you're trying to petition? Is it beyond a reasonable doubt, like what USCIS seems to apply, or is it the preponderance of the evidence, 51%? The statute doesn't say. I believe the regulation doesn't say either. I could be wrong, but the statute definitely doesn't say. And there is binding agency precedent that says when the standard is unclear, not specified, then you apply the preponderance of the evidence standard. That's a matter of Chawaith. Of course, it's not in the Adam Walsh Act case context, but it's the same thing. So the standard of review, preponderance of the evidence, nothing, it's not stated. Mm-hmm. So that's the argument. USCIS keeps applying a higher standard of review. We ran into not trouble, but in the 11th Circuit, other courts have rejected this argument by saying, well, it's completely discretionary. In fact, the U.S. government in our oral argument said, the 11th Circuit asked the U.S. government, if the USCIS woke up one day and said, we're denying all applications that come to our desk on a Wednesday because we don't like Wednesdays, could we review that? And the U.S. government said no. That's how the statute's written. And it won because Congress wrote an unconstitutional statute, but they're upholding it. So that's the argument. It's completely discretionary, so we can't review. The D.C. Circuit rejected that. You have to apply the preponderance of the evidence standard. You can bring this procedural challenge to a no-risk determination. Matter of Chawaith applies. It would appear. Again, another remand for further consideration. But that's a huge deal, too. Huge things. The D.C. Circuit doesn't speak often in immigration, but when they do. I could keep going. Very interesting case about revocation of consular reports of birth abroad from the Second Circuit, but I feel like we've gone long enough.
Which case is that, consular revocation birth? Because I see that issue pop up every once in a while. I don't remember reading that pop up.
Hadwan v. Department of State, a guy in Yemen who he's been stuck there for like a decade. They took his passport and his birth certificate in the consulate. He's been stuck in war-torn Yemen for like a decade, 12 years actually. And they said, pretty unique facts. The fact that he could even get into court's a big deal, so that's a win. But like in this case, there was like an officer there who, I think there were 30 reports of him doing wrong things. This officer got Mr. Hadwan to admit that it was fraud, but he said he didn't understand English and he never signed it anyway. Like the whole thing is crazy. And this officer had this extensive...
How did they get the record? Is that developed in there? How they got the record?
They got the records. I think they got it from another case actually. Yeah. So I don't know how they got discovery in that case. You're right. That is a big deal. But that already existed. But discovery is so important, right? But so there was that. They got on that APA that the Second Circuit did not like the Department of State's reliance on this signed confession, where the accuracy of the signed confession is the whole dispute. So that was the APA, Administrative Procedure Act claim. Then there was also a constitutional claim. These revocation of consular birth abroad, there's a hearing within the Department of State, apparently. And now they can happen in consulates, but at the time they were happening in D.C. And state could have permitted him to come in just for that hearing, but they wouldn't let him. And so at the hearing, no one testified, and Mr. Hadwan lost, even though it was his credibility on the line. And so the Second Circuit
even let him in. Would that technically be a parole? Because if he's a citizen, you can't parole a citizen, can you?
Right. The whole thing is crazy. And so the Second Circuit directed the Department of State to return this guy's consular report of birth abroad and his expired passport, quote, so that he may reapply for a new passport without prejudice, end quote, which I suppose is then going to transfer the whole dispute into U.S. passport.
He's not going to clear yet. I would, for him, I go to Mexico or land border, walk it through, and just not deal with the embassy. Then there's somebody.
Right, win for land border with Yemen.
Yeah, go get a Mexican visa and then show up a CP, and then just be like, just let him in.
These cases are crazy.
Oh yeah,
crazy.
And it's going to get crazier. So I'm just thinking how to mentally deal with it. I remember 6 months we were talking. I was like, la 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 la. I'm like, I was bracing myself for just what's happening, in a way of just numbing myself. But to kind of take the other way, it's like an obstacle course that's coming at you, like these those ninja on TV shows where they have the ninja competitions?
Yeah. Can't numb yourself now. We're through the first Supreme Court term of the Trump administration. Things have gotten real, and we're getting attacked. The immigration bar is getting attacked, of course, by the executive, by the Supreme Court, and now with Congress in this terrifying bill. Don't get me started with Lake and Riley. I mean, I suppose Congress started the party first. So definitely under attack from all sides. I will stay within my circuits talking about good cases and bad. Try not to go insane.
A wild ride, and we'll see what happens with the Republic. I mean, this is like, this is the Republic we live in. Like, this is like, they say empires last 250 years. We're at that exact mark.
I don't even hold up. Well, let's talk about the Byzantine Empire, because like they lasted like 1,000 years. They lasted like 700 years after Rome fell.
They mutate. So like it's like it's the same name, but like the entity and how it operates changes. Like Rome itself, when Caesar came, they killed him, and then his nephew came in, or I guess nephew, yeah. Rome it just changed how it is. It might keep the names and the titles. Like we saw Congress, but Congress for all my lifetime has just been a rubber stamp on the executive.
I see. Here's to not losing the country in our
well,
lifetime.
Who knows? I mean, there could be bifurcated, it could be all sorts of ways, but it's a wild time.
Justice Jackson in dissent. Quote, tragically, the majority also shuns this prescient warning. Even if such institutions may be destined to pass away, it is the duty of the court to be the last, not the first, to give it up. And that, mic drop, but not that it matters.
Pretty good. That was pretty good.
Not the majority, but pretty good. Justice Jackson. Very good.
This is the nationwide injunction lawsuit case. Because the majority just didn't say anything. They didn't explain anything. They just like, it is what it is.
No, the majority.
I just looked at briefly. I thought they just said this is it, and then there was a dissent. I was like, oh, they didn't even like explain themselves. Or
that was in the third country removal case.
Oh yeah, that nasty one. Yeah, that was crazy. The reason
the majority probably didn't say anything is because they knew Casa was coming. So they, but I don't know, to give them credit. Not that that's the appropriate thing to do.
Did we talk about that one last time?
No, the majority, Justice Amy Comey Barrett, with injunctions, they didn't exist in 18th century England, so shouldn't have them here, that kind of thing.
Well, it's, your show's going to...
Smarter people than me will talk about the legal theories underpinning the majority's decision, whether they're right or wrong. Listen to Strict Scrutiny, Amicus, and if the Federalist Society has a podcast,
I have a prediction that your podcast is going to triple and quadruple in ratings the next 2, 3, 4 years. Everyone's going to have to listen to you, see what's going on.
That's too much, man. It's too much.
So quickly, but how was AILA? You brought your beautiful family. The baby was there with a sticker.
Baby was a big hit. I would never say that like me or anyone were like the biggest deal there, but I think we could all agree that he was the star.
Mm-hmm.
He brought joy. He didn't win any awards though, but he was well received, I suppose. Is what I'm trying to say. He was wearing those cool sunglasses. So yeah, you've got to bring your family next year.
They won't come to us. It'll just be a mess. He's gonna run around and have to chase after her and look bad. but who knows? At that time they're a year older. They'll be more tame. But the baby, I should have brought the baby when they were small because that would have been more manageable. They can't run away.
I'd be remiss. My wife is a very busy full-time lawyer. That was not possible without her essentially taking off 4 days.
Did you guys do anything there, or were on the?
We didn't even.
Yeah, for those who didn't go, there was this really big hotel, the Gaylord complex, that they have like all these hotels AILA does, and it was really nice, 5 restaurants and huge, but it's like in the middle of nowhere. I was kind of like, this is Colorado. I went downtown one day for Roman Zelchenko's comedy hour and stuff like that. The comedy hour is good, but downtown, just I don't know, the route that Uber took to thing, I was like not impressed with Denver. I was expecting much higher living standard, have better looking houses, less homeless people doing drugs in the street. That was really like that. I left LA for this. I'm like, what's going on?
I've been to downtown Denver. I didn't do it this time. I don't know what route you took, but it was near the airport. Yeah, we were in the middle of nowhere. They just built a bunch
of apartments that were like empty, and I was like, it was
weird.
And they kind of coming from our direction. I've flown over. Usually when you go on the East Coast, it's like layover flights. You don't see it, but it's all like a big piece of rock from here to Denver. Something on the ground, it's just rock.
Yeah, it's all rock. No, But it was cool to be right there in the mountains. Next year I have it on good authority that it will not be at like that.
I kind of wanted to be at the Gaylord because it's supposed to be like the coolest hotel now, the biggest hotel west of the Mississippi.
In San Diego, you don't want to go down to Chula Vista.
Have you gone to the Gaylord yet? Have you seen it? How that looks, the San Diego?
No, and I've got my in-laws live in Chula Vista. No hate on Chula Vista. I don't want to get the hate mail, but like, come on, you're coming to San Diego. Yeah, let's go downtown. Let's go to the beach.
Gaslamp, is it Gaslamp called the Gaslamp district? Yeah,
it's not cheap, but there's much more to Gaslamp. It's right at Little Italy. There's
no, we go like it's like the zoo is there and Legoland, and we always go and drop by just go eat at San Diego. So we go there a lot. But last time I went to Gaslamp, it was like a couple weeks ago. It was like not as it's very cold. First of all, San Diego all the time. Sorry to complain. My New Year's resolution is just complaining. God is great. Life is good.
You have no business being in Gaslamp. That's the problem. You and I we're old men for Gaslamp. That's the problem. You don't go to Gaslamp. That's not. They don't want you. You don't want them.
I am an old man now because of one fair sentence. I bashed L.A., Denver, and San Diego. So I'm like old.
Yeah,
complaining about the old days.
Not only that, you're an old MAGA man. I don't know what.
No, don't accuse me of that. That's for sure.
Actually, you're gonna be start
I always think because it used to be so much fun. It used to be so much fun. Like you go there, food, walk around.
Okay,
yeah,
the good old days. The good old days.
The San Diego's really cool too. Gotcha. Like I don't remember. The zoo was not what I remembered it when I went. LA Zoo, which usually was weaker zoo, it is looking better right now. That part was disappointing, but I'll leave it at that. I'll never complain about me. Overall, it's June going to be there. It's good because every other time I go to San Diego, it's too cold. It's always windy there. Is that fair?
It's not. It's cold. It's not so windy.
It's like a cold that gets in my boat. I'm not sure if I'm a cold person, but every time I'm there, I'm like, I got to wear like 2 jackets. Yeah. I'm like, this is like summer already. Why is it so cold here? Yeah. So I want to enjoy the beach and walk by that Navy ship, like the thing. But enough of my complaining. Thanks so much for coming and bearing with me. It's been years now that we're doing this. It was always good to see you in person. Hopefully we get a chance to see each other again before next June, but we'll see. That works out.
You know where I am.
Sure. I got to meet your friends over there too. We have one colleague, Josh Altman. He said he meets up with you.
Oh yeah, Josh Altman, very smart guy. San Diego federal litigation practitioner, also from EOIR.
Yeah, it's a great thing about a conference. Get to just connect with everybody, meet new people, and a lot of listeners and stuff. So I'm sure you have the same people just stopping you and saying they listen all the time, that kind of thing. All right, bro. Cool, stay on the line for 2 minutes or so, but thanks so much for coming on again.
No problem. Bye, John.
All right. Thank you everyone for listening. What a great episode. Thank you, Kevin Gregg, for coming and supporting the podcast. And definitely catch him on Immigration Review Podcast, where our podcasts are found. Really groundbreaking stuff for a guy to do a monthly episode like this, weekly, and just hitting those cases. I'm going to try to do it again with my top 10 and top 10 things I've learned. Also, these AO decisions. But we did the most recent EB1A AO was the previous, I think of the previous episode of this one. That got published. Check it out. I go over and analyze the EB1A AO decisions, appeal decisions from February 2025. And then you through it, you can see how I analyze these cases, how much knowledge and understanding I bring to it. And so if you're interested in getting actually practical EB1A, the application package, how to put together redacted copies, we have the course for you, our EB1A course. Check it out there. So listen to the previous podcast, see what you think about me explaining stuff. And then from there, purchase the course and start your own practice area that comes with office hours. There's mentorship involved. That's the most important component of it. So I look forward to hearing from you. But having said that, have a good one. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.